I guess now we should start this session. Hello.
Yes, Paswat.
Yes, ma'am. So, hello, good afternoon, everyone. This is Bhashat Prakash from the Law Junction, and we would be the moderator for today's event. So, the theme for today has been decided is that Preamble, the Constitution of India, in which we shall dissent and dwell into the topics: is the judiciary overpowering the ideals of the Constitution in the modern society? Preamble was the key to open the minds of the constitutional maker. It set out the whole framework in which the whole constitution is built. It declared India into a sovereign, socialist, secular, democratic republic. It secures not only the social but also the many factors of the constitution. The article of the constitution and the directive principle reflects the ideas upon which all the things has been built up. So we would be over here discussing many of the aspects, and the biggest of the Keshavananda Bharati, consisting of the 13 judges examined each aspects of the constitution. And even we will be also noticing that how present constitution is being demotivated and being suppressed by our judiciary. Talking about the law junction, in we the law junction over here to present this webinar and to host it on the motto to our mission to show a background that how we can provide to all our legal profession people, students, professionals in one platform and provide them with different aspects of the comprehensive team approach. For today's seminar, we have with us our dais the guest of honor. We have Assistant Professor Ms. Anu ma'am, Anu Solanki Kamble ma'am, who is a very big, great teacher and a facilitation from different publications and a content writer with a demonstrating history of work. She is an assistant professor in Ajinkya by Patel University, Pune, and a visiting faculty of Symbiosis School, Pune. She has a very wide aspects from different field of being in this profession with an LLM focus in banking, corporate finance, and securities law. Ma'am is not only stick to one place, she is of a different kind. She has such a talent to acquire at one place and to direct the students how to form and a depth knowledge of a constitution, where you can find that the research and online done by a ma'am is very good, consisting of different contents. And the main basic thing is that she also runs her own YouTube channel, namely Legal Batter, where she describes how to learn and how to inculcate different types of activities through which you can memorize your legal profession. And also, not only leads to that, but she has a very good and appropriate knowledge consisting of different aspects where you will find her a pinpoint faculty with constitution knowledge, legal provisions, and many of the vocal communication. So over here, I would like to give to our ma'am, Anu Solanki Kamble ma'am. Next to you, ma'am.
Thank you so much, Bhaswat. Uh, Good evening, everybody. Wishing everybody a very, very happy Republic Day. Please excuse my voice for today. I have a sore throat, so I hope it's not, irritating to listen to. I'm going to try my best to keep it simple and to the point. As many of you may know, my style of teaching is interactive. I do not believe in passing on knowledge or any information that I have in a one-sided manner. I always believe in a healthy, productive discussion. So I'm going to follow the same style for today as well. I will be laying down certain guidelines for today's session, what all we will be discussing. And then I will definitely want you guys to contribute to as well. I know that I want to learn as much as you guys want to learn from me, and I hope this learning process is mutual. All right, so the topic for today is preamble, the constitutional key. Now, before we delve into the preamble of our Indian Constitution, let us first understand that what do we mean by the word constitution? Oh, sorry, the word preamble. The word preamble is usually considered an introduction or an introductory text to an enactment or a law. If you look at the source of the word preamble, the word has been sourced or originated from the word preambulus, which means an introduction or to go before. So that is why whenever you go through an enactment, whenever you come across a legislation, a statutory law, you will always see the preamble right after the title of the act. Now, what does this title do? What does this preamble do? It basically lays down, one, what is the purpose for that law? Why was that enactment? Why was that uh, legislation passed by the parliament in the first place? Secondly, it will also tell you the source of the enacting power. So when we apply this in the context of our preamble to the constitution, the Indian constitution, the preamble to Indian constitution regulates two aspects. One, it gives you the structure of governance. So if you look at the preamble to our constitution, it has two parts. One, it tells you what kind of government is are we aiming at. So words like socialist, republic, secular, democratic are indications of features of our governance. How should our governance look like? The second part of the constitution are the ideals that are expected to be enshrined so that they are followed, and people who reside in India over whom the constitution is binding, what are the ideals that will help in healthy governance? So words like justice, fraternity, equality are indicators of the ideals that one expects the constitution to fulfill. Now, having said that, there are different interpretations, introductions to what a preamble means. For example, Plato, a celebrated jurist and academician, considered preamble to be the soul of the law. Now, why do you think we consider preamble as preamble in general? Why do we say that preamble is the source of law? Would anybody like to help me here? Yes, anybody? Ganga, what about you?
Ma'am, I think preamble lays down the as a framework or guidance of what should be done or how it should be followed. It lays down the basic instruction, the fundamental instructions in the following would be interpreted, or the following would be the rest of the document would be followed.
Yes. Nanika has also mentioned something in the comments. It is rightfully considered to be the soul of the constitution because it lays down, one, why was that law, why was the constitution enacted in the first place, and secondly, what all or in what all manner should this constitution be applied. Purvarun, exactly. Establishment of a social welfare state is one of the ideals enshrined in the constitution. Now, the agenda for today's session, I've divided it into 4 parts. We will first understand that what does our Indian constitution preamble contains. What do we mean by preamble? What does the constitution's preamble contain? Thirdly, do we consider preamble to be a part of the constitution? Because once we answer that question, we'll be able to answer the 4th question, which is that should the judiciary really be considering preamble while they interpret constitution or any other law? Just give me a second. I see somebody has raised their hand. Do you have a question?
Shri Ramdev Associates, can you please? No, ma'am, you may please continue.
All right. Yeah. So the 4th point for the agenda would be, really be a key to interpret, and should the judiciary be considering that while they interpret the constitution? So we'll focus solely on the preamble. What is preamble? The role it plays, and whether it should play any guiding, should it be considered as a guiding force behind the interpretation by the judiciary. We've already looked at what is preamble, what do we mean by preamble, how is preamble defined. Now let us look at what all terms, key terms, are contained in the constitution's preamble. The first word that we come across is the word sovereign. Now, sovereign is manifested in the very first line because the preamble reads as, we the people of India give to ourselves. And when you move towards the end of the preamble, it says we give to ourselves, we enact, and we give to ourselves. So these are the indications that we are a sovereign country. What do we mean by sovereign? That we have the power to rule ourselves. We do not have any external ruler. There is no other authority that is above us. We are the most sovereign of all, and that is why we, the people having the sovereign power, will translate that, delegate that power to representatives of the government. And that is how those government representatives, the MLAs and MPs that we select, are going to rule us. So they do not have any authority of their own. The authority passes on to them because we are a democracy as well, and hence the word sovereignty exists. If you look at the provisions of the Constitution, okay, did somebody have a question? I see a couple of comments. Let me just note that down. Yes, Sachin, you're absolutely right. It is an introductory or an explanatory statement that explains the purpose and the authority of that particular statute. So when you look at the preamble of our Indian Constitution, it does lay down the source of the enacting power, because it says, we the people of India. So who is the source of that enacting power? Where is that power to enact the Constitution is coming? It's coming from people like you and me. Secondly, as I said, it lays down the structure of governance. कैसी government होनी चाहिए? It should be socialist, it should be secular, it should be sovereign, it should be democratic. ये हमारे government के features हैं जो एक Indian government में apply करते हैं, both at the central as well as the state level. The third aspect that our preamble covers are the ideals that need to be met for absolute governance, able governance of the country. So when you look at terms like equality, when you look at terms like fraternity, justice, all of these are very important, without which the first part of the preamble loses its meaning. There's no point of you having a democracy. There's no point of you having let's say a socialist state or a secular state, if on the other hand you're going to disequate people, or you're going to discriminate people on the basis of religion. So if you have to maintain secularism, which is no religion, you are not anti-religion, but you're also not pro any particular religion, which is manifested in Article 25. For that, it has to be ensured that in the ideals enshrined in the preamble, which is equality in all respects, political, social, as well as legal, it ensures that you do not treat people in different way or in a different manner based on their gender, religion, caste, creed, race, or anything of that sort. So moving from sovereign, the next word that we have is socialist. Any idea what do we mean by the word socialist? बहुत सुनते हैं हम लोग. What do you think would be the meaning of the word socialist?
Socialist means welfare state, ma'am.
Yes, Shivanand, go ahead. Chetan, would you like to add something? Yes, Rihanna, you're almost there. It is about the benefit of the society, but it is more focused on taking away all forms of inequalities that exist in the society. It is about equitable division of resources in a society. You have to ensure that you are not letting the rich becoming more rich, and you're not going to do things because of which the poor will never be able to raise before that, or they will not be able to rise before that bar. So when you look at socialism or socialist as a aspect of governance laid down in the preamble, it simply means that it is the government's responsibility to ensure that there is equitable distribution of all sorts of resources. And where is that vested? Where do we see this ideal enshrined? It is there in the Directive Principles of State Policy. The next term that we come across is secular. As I already told you, Article 25 is a manifestation of that, because secularism or being secular means that the state will not be pro any particular religion, and every person will enjoy the right to profess and practice their religion in the manner that is suited to them. The next term, important term in the preamble, is democracy. Now, democracy or democratic and republic are the two terms that a lot of us tends to get confused. However, there's a slight difference. Democracy allows you the right, or the right that vests in the people to choose who will run them or rule them. Whereas republic means that you have the power to elect in the first place. It's not going to be a hereditary system where the head of the state will be coming based on the dynasty or the family that they belong to, what we see happening in Britain or other forms of monarchies. But republic means that people have in themselves the power to choose who's going to govern them. And democracy further complements republic by saying that not only do you have the right to choose who will govern you, you also have the power to choose who will govern you. These are two different things. However, they're related, and they're both features of our Indian polity as provided in the preamble. Now, these were the characteristics of governance or features of governance that the preamble it strives to achieve. Next are the ideals that are enshrined. Those are four. We have justice, liberty, equality, and fraternity. Now, justice, again, is subclassified into three kinds. We have social, economic, and political justice. All these forms of justice are not only enshrined in the constitution through the preamble, but there have been time and again instances before the court where the courts needed to re-emphasize the fact that justice does not mean an abstract idea. Justice is a moving organism. It's dynamic, and it is supposed to change itself. It is supposed to modify itself according to the changing needs of the society. When we move to the third part of our discussion, I will be discussing certain cases where the judiciary had done that. The next ideals enshrined is liberty. Now, what do we mean by liberty? Liberty is the freedom to do. Now, various freedoms laid down in Article 19 are the manifestation of this liberty. Specifically, the most fundamental of them is the liberty of, or the freedom of speech and expression. That is there in Article 19, Clause 1, Subclause A. Moving on, the next term that we have is equality. Now, equality has to be not only equal treatment, between each other. There should not be any disparity. There should not be any discrimination on any grounds. It's also equal protection of law with no discrimination. So whether you are rich or you are poor, whether you are a male or a female, whether you are somebody who's confessed to his crime, whether you are somebody who's, there's primary evidence to prove that you did in fact commit that heinous crime, yet because of equality, because of this ideal enshrined in the constitution, we have, in India, for example, some of you may know that when Ajmal Kasab was on trial, nobody in the Bombay Bar Association was willing to represent him. Nobody was willing to become his defense lawyer, because of which, the trial went pending for a while, and it was only after the state legal services authorities, they they appointed a person from the legal aid committee to become the lawyer, to become the advocate for Ajmal Kasab. Even though what he did, there was absolute unquestionable evidence. There were eyewitnesses, there was CCTV footage, there were so many other forms of evidences and proofs that could not be rebutted. His culpability was well proven. And yet, to give him that chance that he's treated equally like any other person would have been treated had they been subjected to the judicial process, this is an indication that as a principle enshrined in our preamble, equality is of paramount importance. The last term that is contained in our preamble is fraternity. Fraternity, in simple words, means brotherhood, bhaichara. So you have to understand that all these terms that I just told you are not isolated concepts. They do not exist in isolation. I gave you an example previously where some or the other will have a relation with the other word, or it could be multiple words having a relation with the other word. Like I told you, how secular and equality go hand in hand. If you are trying to say that you're a secular state, you will have to ensure that you will not be treating people differently in your state based upon their religion. It will not be in matters of employment. It will not be in matters of academic admissions or any other forms where resources that the government is providing is going to be in consideration. So that is why each of these terms are interrelated to each other, and at the same time, they're independent to each other as well. There have been different cases where these aspects, these ideals, in some or the other forms, have been interpreted by the Constitution. So far, we have tried to understand that what is the preamble and what does the preamble to the Indian Constitution contain. Now, coming to the next most important question, is preamble considered a part of our Constitution? Can anybody tell me why is this question relevant in the first place? Why do you think we need to discuss at all whether Constitution is a part of the, sorry, preamble is a part of the Constitution or not? Yes, anybody?
Ma'am, I think it arose from the Overpowering Union Exchange of Principles in 1960, as we were taught in class. After
Yes,
that, in Keshavananda Bharati, it was that view was rejected as to preamble not being a part of the constitution.
yes. Thank you, Niyati, for stealing my thunder because I was going to talk about those two cases. But nevertheless, just joking. As Niyati rightfully pointed out, these are the two most important cases when it comes to understanding that what does the judiciary think about preamble being a part of the constitution. Now, whereas in the Berubari case, which was a reference case that arose before the Supreme Court in its advisory jurisdiction under Article 143, hence, before the name of the case, which is Berubari Union Conclave case, you will see the word in re, which means in reference. So under Article 143 of our Constitution, the Supreme Court also is vested with advisory jurisdiction. So that was that is how the matter arose before the Supreme Court. That was the first time where this issue had to be decided, that is preamble a part of the Constitution or not. The court in that case, it was a 8 judges bench. They stated that no, it is a key to open the mind of the makers of the Constitution, but it cannot be considered as a part of the Constitution. However, this was reversed in the Keshavananda Bharati judgment, which I am going to come to it later, since that is an important, standpoint in the jurisprudence relating to development of preamble. My first question is still not answered. Why is this question relevant in the first place? That is preamble a part of the Constitution or not? वो है या नहीं है, उससे क्या फर्क पड़ता है?
Ma'am, for the purpose of amending the constitution or for the purpose of amending the preamble, ma'am.
Exactly. Thank you, Sumitra. And that is why Keshavananda Bharati becomes probably and rightfully so, it is the most important case in understanding the entire constitutional jurisprudence. Not only it gives you an idea and it answers, a very important question, that to what extent can the parliament amend the constitution? What is the scope of this amending power? That's a very important question that a 13 judges bench decided in Keshavananda Bharati. But even more important than that, it helps you in deciding that if you consider preamble to be a part of the constitution, it goes without saying that you cannot amend the constitution in a manner that will be inconsistent with the preamble or the contents of the preamble. So all these 9-10 terms that we just discussed, these are, as I told you, these are not abstract principles. These are actually to be seen in motion. These are actually to be considered as reference points by the judiciary whenever they're deciding or interpreting. Either they're interpreting any provision of the constitution, substantive or otherwise, or whether they're interpreting any other provision of any other law which derives its authority from the constitution. So either way, preamble becomes an important aid to interpretation. When we study this, course, statutory interpretation or interpretation of statutes, we always talk about aids to interpretation. We have internal aids and external aids. And we are always going to count preamble as an internal aid. However, there were conflicts between different judicial pronouncements, Berubari and Keshavananda Bharati being the most notable of them. But the question now stands decided that preamble is indeed a part of the constitution, which means that while you are interpreting the constitution or while you're interpreting any other law that derives its authority from the constitution, you will have to keep in mind the principles, the terms, the concepts that are enshrined in our preamble. So it all started with, I'm sure some of you may know that Keshavananda Bharati case arose from a long line of judicial precedents, which all started with the case of Sajjan Singh, where eventually the court held that Parliament does not have the power, Parliament has the power to amend the constitution. This was in reference to Article 368, and the word amendment there was the notable point of contention. There was, the side that contended that amendment means that amendment will not be considered within the definition of law as it exists in Article 13. So, in order to understand Keshavananda Bharati and the entire chronology of all those cases, from Sajjan Singh to Golaknath to Keshavananda Bharati to I.R. Coelho, S.R. Bommai, you also need to understand the interplay between Article 13 and Article 368. Article 13 tells you, so 12 and 13 are related because 12 gives you the definition of state. And then 13 goes on to say that if the state will make any law in contravention to the rights laid down in part 3, which are your fundamental rights, then such laws will be void. And 368 gives power to amend the constitution to the parliament. And it was in this light the court was confronted with the question that can you allow the parliament this excessive right, this overpowering right, that they can include anything within their ambit while they decide to amend? Will it also include amendment, meaning thereby that can amendment also be held as unconstitutional because of Article 13, or will it apply only to law, which are your primary laws? Amendment is always a follow-up to a primary law. So this was the main question. Prior to this, the two noted established judicial authorities were Sajjan Singh and Golaknath. Golaknath was an 11 judges bench decision, and hence the need. All of us know that Keshavananda Bharati made 13 judges came together. But a lot of us may also not know that why 13 specifically? Why not lesser? Why not more? Because they were trying to challenge, or they had to reconsider the decision given in the Golaknath case, which was an 11 judges bench. There, the court had to decide whether, law is included, amendment is included in the word law in Article 13 or not. The court in that case held that yes, it includes, but it does not give absolute power. So Sajjan Singh and Golaknath are like two ends of the spectrum. Sajjan Singh बोलता है पार्लियामेंट के पास अमेंड करने की पावर है, चाहे वो अमेंडमेंट फंडामेंटल राइट्स की क्यों ना हो. दूसरी तरफ गोलकनाथ बोलता है कि नहीं, पावर नहीं है कॉन्स्टिट्यूशन अमेंड करने की पार्लियामेंट के पास. So now Keshavananda Bharati had to reconcile and harmonize these two extreme decisions. It couldn't go with either of them because then it would have not rendered any clarity to this conflict that had arose. You couldn't take away the power because that is the power vested in the parliament through the constitution. But at the same time, you could lay down certain limitations to that power to ensure that they do not usurp the power of the people who are the primary source of that law. So moving from Berubari to Keshavananda Bharati, it was held that constitution is indeed a part of the, preamble is indeed a part of the constitution. However, an important issue that arose before the court was that do you consider, and it's not only Keshavananda Bharati, but yes, because it's the most celebrated case, we tend to discuss it there. Do you think that state, when we look at the definition of state in Article 12, can we include judiciary in its ambit? I am inching towards my next point, which is that is the judiciary bound by the principles laid down in the preamble while they interpret? So in relation to that, do you think that Article 12 in its definition of state should include the judiciary as well? Let me simplify it for you. If we say yes, that state under Article 12 will include judiciary, this would mean that when judiciary lays down a law, when it pronounces a judgment, and for somebody, if they believe that this is a violation of their fundamental rights, they can file a petition under 32 before the same judiciary stating it to be seeking enforcement of their fundamental rights. Do you agree? What do you guys think? Should judiciary put it in that definition or not? All right, let me make it easy for you. There was the famous case of A.R. Antule versus R.S. Nayak, where in the year 1984, the Supreme Court with finality held that there could be certain situations in which the judiciary can be included in the meaning of the word state that exists in Article 12. However, the bench seems to classify the role the judiciary plays into two categories. One, when the judiciary is working in a judicial capacity, and second, when the judiciary is working in an administrative capacity. So the bench held that when the judiciary is working in its former capacity, which is judicial, then it is not included in state under Article 12, and hence no writ remedy can lie against it. Whereas if the judiciary is doing or undertaking some administrative acts or administrative conduct, then in those time, during those time, the judiciary will be included in the definition of the word state, and accordingly a remedy to that effect can be sought. So having understood that judiciary is also susceptible to be considered within the definition of state, it becomes very important to understand that is constitution, and within the constitution, the preamble, really the key to interpreting the constitution and its application. Now, I remember reading this somewhere that the primary purpose of preamble, or why preamble to a constitution exists, is to help in understanding the mischief that you're trying to remedify by enacting the constitution. Now, if you guys may have any idea about the 4 rules of interpretation, the 3 basic rules of interpretation, mischief rule is one of them. And it is in that line that this entire discussion about the mischief that the law is trying to remedy, the preamble contains elements of that. What do I mean by mischief rule? It basically means 2 things. One, that it lays down the scope of how far are you going to interpret the constitution, which is the legislation in this case. And secondly, you will only interpret it, you will only apply it to the extent that it allows you to encourage and uphold the principles of the constitution, nothing more, nothing less. So mischief rule is about a balanced approach to law. Literal interpretation is about applying the law literally. And for a while, if you look at the stages of how the constitutional interpretation has undergone changes, there have been essentially stages to that. The first stage was literalism, where the earlier decisions, right from Berubari to the same judgment that the court gave in Menaka Gandhi, the same case had arose before the court almost 20 years ago in another case. In that case, the court did not accept it. But 20 years down the line, the court accepted that for any procedure that allows you to take away or deprive a person's right to life and personal liberty, that procedure needs to be just, fair, and reasonable. This came into judicial interpretation, and it became a part of constitutional jurisprudence only after 1978, when the Menaka Gandhi case came. But prior to that, it was contested, it was argued, but the court never picked it up. Why so? Because there was a time that the court was following the law literally. ADM Jabalpur is also a classic example of that. Why? Because the court in that case decided that Article 21 is the only rule of law that we apply. Okay, I see a raised hand. Lallan, you have a question? If you have a question, please ask.
Lalan, you can please unmute yourself.
Okay, I think they're not there. All right, never mind. Yes. So now we move on to the 4th part of our discussion. Having established that judiciary is open to be included in the definition of state under Article 12, which means that judiciary is bound to uphold the fundamental rights. Not only does it have the power to enforce those fundamental rights through Article 32 and 226, it itself has the responsibility, it has the obligation to ensure that it does nothing that would violate those rights. One could actually read these two things together to understand the present stage of judicial activism, or as some people like to call it, as judicial adventurism. Why do we consider, or why do we see happening in India specifically, that our Supreme Court and a lot of times our high courts of different states take it upon themselves to interpret provisions in a certain manner, in a more elaborative manner, to make it more justice oriented and to give it more value? We have to understand, and I like to use this statement whenever I am teaching my students, that there's a reason why the word administration of justice is associated only with the judiciary. It's not a function that we associate with the legislature or the executive. There's a reason why it goes only with the judiciary, because the purpose of judiciary is not only to locate the correct law and apply it. A higher purpose is to locate first the correct law, and second, to apply it correctly, to apply it in the proportion that it is needed. That is why you will come across cases where the facts are exactly the same, the question of law is exactly the same, however the decisions are completely different. It could only happen in a country like India, where not only do we go by the literal interpretation of our preamble while we are interpreting provisions of law, including the constitution, but at the same time, we also limit ourselves. There have been many cases, including Keshavananda Bharati, where the courts have time and again stated that you can't really go running to the preamble of our constitution every time you feel there is some ambiguity. If there is no established ambiguity, if the text of the law, of the constitutional article in itself is clear, there is absolutely no need for you to refer to the preamble. It should only come to your aid, it should only come to your help when there is an ambiguity that you're not able to understand the purpose of that law. That is why you go back to preamble, look at the terms, and then you keep that in mind while you are interpreting that law. So if you look at the judicial interpretation of preamble, I may, if you may allow me, I can probably, there are cases for each of the term that are there in our preamble. If you look at the word, let's say equality and equal treatment, equal protection of all laws, there have been so many cases where the Supreme Court has reiterated equality, its importance, as well as it has allowed equal treatment or equal protection before the law. Keshavananda Bharati is a classic example of that. We also have so many other cases where some or the other form of affirmative action was questioned. The courts have focused on equality and they were able to give such a classic judgment. If you look at the word justice, now justice is it's a variable concept, and there have been different cases where the judiciary has interpreted different aspects of justice. For example, justice is not it's not a abstract concept. For example, justice definitely will include speedy trial. So the court in the case of Husainara Khatun did pronounce that it is an important part of Article 21 when you do allow somebody the right to life and personal liberty, and you allow the law to take that right away owing to a legal procedure, you will have to ensure that they are entitled to a speedy trial. If they're going to languish in the jail for 20 years or 30 years, and only after that you're going to realize that, oh, this person is innocent, they did not commit that act, or there's no plausible evidence to prove their guilt, and therefore you will have to acquit them. This is going to be a mockery of justice. Again, in the case of M.H. Hoscott, which is an established precedent to understand legal aid or free legal aid, the court understood that the word justice will not have true meaning unless and until you're going to hold and allow everybody to avail it. If I am a person who cannot afford the lawyer's fees, but I have a case that has been filed against me, in the absence of me being given adequate legal representation, there is a likelihood that nobody will hear my side, and there's a likelihood that I may end up getting convicted for something that I did not do. And that is why legal aid, free legal aid is a very important interpretation and extension of the word justice that exists in our preamble. Another important case is the case of Sunil Batra versus Delhi administration. This was the case where the court held that solitary confinement was unconstitutional. Why? Because it is against the idea of justice and it is also against the idea of equality. How will you decide that certain accused, certain convicts are to be kept in solitary confinement? Some of them should be susceptible to, what do you say, increasing periods of solitary confinement. That in itself is unconstitutional because it is creating inequality between various classes of convicts. In the case of Nandini Satpathy, the court again held and gave importance to a right of an accused to consult their lawyer. It would have been bare justice. It would have been justice in theory if you do not allow people to consult their lawyer before they had to take any decision, if they had to sign a statement, if they have to make a confession, or anything of that sort. So, justice probably is the term that I believe has been widely interpreted and rightfully so by the Supreme Court in various cases. If you look at the words liberty, then liberty as a concept was reiterated and manifested by the court in the case of Ramesh Thapar versus Union of India. That was the case where the court held that yes, you do look at Article 19 Clause 1 and 19 Clause 2. You have to read 19 Clause 1 in light of 19 Clause 2. What does 19 Clause 2 contain? It contains reasonable restrictions on the freedoms that are there under Article 19 Clause 1. But unless and until you are stopping somebody or inhibiting somebody's freedom of speech and expression because expressly it will have any effect on the security of the state, unless and until that is the case, you cannot impede upon, you cannot violate, or you will not be allowed to restrict a person's freedom of speech and expression. So in the Ramesh Thapar case, the ideal of liberty that is enshrined in our preamble was upheld. In the case of Navtej Singh Johar in 2018, I believe was a very, very good year, so far as constitutional values and constitutionalism is contained, because that year we saw a lot of landmark judgments coming from the Supreme Court. One of them was the case of Navtej Singh Johar. Who's going to tell me how did this case cater to the idea of equality that is enshrined in our preamble? How do we connect Navtej Singh Johar with equality? Come on. Yes, Shivam.
Ma'am, because the case was challenging our constitution.
Yeah. So, yes, Lovely. Go ahead.
Ma'am, it was a discrimination for gay community and for lesbian and transgender community, and for not allowing them to have sexual practices in private also, and it was an unfair treatment as well. They are human beings as like us, but they were excluded from all this even though they do have the same human heart, feelings, and each and everything.
Exactly. Thank you, Lovely and Shivam. It is probably, one of the classic cases. There are various other cases, but probably one of the best cases to understand equality and the role that this concept plays, in the understanding of homosexual communities' rights. In the Navtej Singh Johar case, the question before the court was the constitutional validity of Section 377 of Indian Penal Code. Now, IPC, and through Section 377, tries to criminalize or punish any sexual act which is against the course of nature. That's what it used to do. It's a colonial law made by the British. Britishers have so far in their own country repealed that law against homosexuality long ago, but we are still stuck with it. At least technically, we were still stuck with it till 2018. There is a judicial history to it. So if you look at cases like Nas Foundation, Suresh Kumar Kaushal, and various review petitions that were filed after that. Just a minute. So if you look at all these cases, it all came boiling to the case of Navtej Singh Johar. The court had to decide that, do you allow, if you do not have any problem with the heterosexual community performing sexual acts in private, why is that inequality or why is that discrimination applicable to the homosexual community? If on one hand we look at the burning question of why is marital rape still not criminalized, which happens between a heterosexual couple. The couple may be married technically, but the important element of consent, if missing, is not considered important in marital rape. So the question the court had to decide was, do you allow this inequality to prevail when on one hand you have no problem with whatever heterosexuals do in the privacy of their homes, you do not even punish acts of marital rape, but on the other hand, if homosexuals were to do a similar act in the privacy of their homes, it is between consenting adults, then definitely it will amount to just give me a second. I see a couple of raised hands. I'm going to take those questions. So the court had to decide that will they allow this inequality to prevail? Is it capable that you could segregate some parts of Section 377? That you could segregate some parts of Section 377 which were violative of the fundamental right, specifically Article 14, 19, and 21. Yes. Loveleen, you have a question. Tell me.
Ma'am, talking on marital rape, doesn't this amounts to like mental cruelty and physical violence? And it is not just a matter of consent. Well, if your consent is not given, it eventually hits you in another way to cruelty and a physical violence.
It is, and Loveleen, that's a very good point, because I remember reading this somewhere the other day where they were making arguments, in favor as well as against marital rape, and this is an important question that when you just because, and I think it's connected, because if you look at Section 13 of the Hindu Marriage Act, which provides you with the grounds of seeking divorce, and if I look at Section 13, Clause 2, where certain additional grounds are provided to the women that she can seek divorce from her husband. One of the grounds is if the husband has been held or has been convicted of offenses like rape, sodomy, and incest. The law gives more, the law is ready to acknowledge that the person has been convicted of a sexual offense and the women can seek divorce on that. But it is so unfortunate that the women cannot seek divorce on the same ground if she is the victim of that rape. So that's a very valid point, and I hope it is taken into due consideration, and we do see in the near future a law that criminalizes marital rape.
Yes, ma'am, looking forward to it.
Yes, there's another student. I'm so sorry, I'm not able to pronounce your name, but Shaiza, go ahead. Okay, meanwhile, we can take Chetan's question. Yes, Chetan?
Ma'am, you don't think that if we will criminalize a marital rape, then it will going to be misuse against a man? Then how we can prove that it is marital rape or not?
Chetan, that's also a very valid point. But I believe that if we are going to discourage marital rape from being criminalized only on the ground that it is susceptible to be misused and abused by the female community, then we should not have laws punishing domestic violence, matrimonial cruelty, because those are also misused in a massive way. That argument cannot hold ground in, against marital rape. Just the fact that it can be misused, probably, with more and more jurisprudence, the judiciary and the parliament can come together to formulate exhaustive guidelines, objective guidelines, to probably make it easier. Like as I was answering Loveleen's question, it could be a better way that instead of criminalizing it completely, you could allow that to begin with. You could allow that as a ground of divorce. Like Loveleen said, it is a form of cruelty, both mental and physical. So if you could allow and fit that into the definition of cruelty, which is a ground of divorce, I think that would be the first step in that direction. Criminalizing it sooner or later, see, we understand we are evidently a country that that considers matrimony or marriage to be sacrosanct. So we cannot really assume that the concept of rape goes antithetical to the idea of marriage. But probably if you look at the chronology at the time when this law was made and how far we have come, we now have a very pronounced and a very, very expansive understanding of the word consent. And I think if you look into that, marital rape does become a problem. So it should be criminalized. Chetan, do you agree?
Yes, I agree, but not completely,
I'm
because there is a holy relation with a husband and a wife. A
Yes.
wife cannot change her relation with her husband.
Hmm. Yes.
But if we allow to criminalize it with in this manner that the consent should be compulsory,
Hmm.
but it is very difficult to prove that there is a chance of a marital rape.
Yes.
There
See,
is a large conflict between that how we will it prove that there is a rape or not. That's
absolutely.
all about
Absolutely, Chetan. Thank you. Thank you for adding that point. Yes, I think there was another raised hand. Anybody else had a question? All right, moving on. Uh, the last thing that I want to talk about before I close in for the day, going back to the theme of this talk for today, is the judiciary overpowering the ideals of our constitution in the modern society? I believe I'm an optimist by nature, and I practice the same thing. I believe that we have examples of both kinds where the judiciary has been the beacon and the flag bearer of so many human rights, which it has been able to successfully incorporate, within Article 21. And there are also certain bleak instances where the whatever was expected from the judiciary, they were not able to do so, like the ADM Jabalpur case. But thankfully, even those cases which were a stigma on our judicial, jurisprudence, those seem to have been taken away with elaborative liberal judgments like Puttuswamy, Navtej Singh Johar, Anuradha Bhasin, and so many more coming away. I remember in 2020 reading about this case, the Anuradha Bhasin case, where the Supreme Court held that right to life not also includes right to internet. In this era of information technology, in this era of virtual communication, and the dire need that people have for it, specifically in certain areas which otherwise would be cut from the country, they will not be able to stay connected. Internet today is definitely become a necessity. It's essential requirement. We cannot classify it as a luxury anymore. And so we do see that through all the cases that I told you about, all those cases, right from Keshavananda Bharati to Menka Gandhi to Ramesh Thapar, Neelvati Bahera, M.H. Hoscott, Hussainara Khatun, all these cases, they do indicate that in the modern society, the majority role that we see our judiciary playing, the Supreme Court specifically, they do play a positive role in the sense that they do try to imbibe the principles laid down in the preamble of our Indian Constitution, and they try to consider that as the guiding force behind their decisions. There have been so many cases where the Supreme Court or the High Court was confronted with the issue which went against a certain sentiment. They had to decide what would be the best for the society at large. For example, when you look at, let's say, I think, yeah, Niyati, you have a question?
No, ma'am, you continue. I'll ask you after you're done.
Okay. So if you look at the Puttuswamy judgment, which was the case where the court gave this judgment that right to privacy is a fundamental right. It's an unenumerated, but it is a fundamental right nevertheless. Giving somebody the right to privacy will always be antithetical to right to information, which is already an established part of our constitution. We have the RTE Act as well. The court could not. So we have this principle of another principle of interpretation, which is harmonious interpretation. You have to interpret and apply laws in a manner that one law does not take away the applicability and scope of the other law. This applies both inter-statute, so one statute vis-a-vis the other statute, and it also applies intra-statute, within the statute also. ऐसा नहीं है कि आप एक सेक्शन को दूसरे सेक्शन से अलग हटके या अलग तरीके से आप अप्लाई करोगे. Probably the best example that I think of the latter category is Article 15. Article 15 of our Constitution has 4 clauses. I want to draw your attention to Article 15 Clause 1 and Clause 4. Who can tell me what is 15 Clause 1? सबने पढ़ा होगा Constitution में. Yes, there's somebody with the username Inner Peace. Would you like to answer?
Yes, ma'am.
Yes, ma'am. Hello.
Yes, go ahead.
मैम 15 का 1 पता है, 4th पता नहीं. 1 में शायद ये है कि nobody should be discriminate on the basis of race, caste, sex, birth, place of birth.
Yes.
मतलब
Lovely.
State cannot be discriminate. Yeah.
Yes, state cannot discriminate. Lovely, you want to add anything?
Yes, ma'am. I was about to tell you about clause 14.
Okay. हाँ, मैं उस पर भी आती हूँ. बहुत important है वो. Just hold on to that point. 15 clause 1 बोलता है the state will not discriminate. अब 14 और 15 का ना ऐसा है कि you can consider them वो एक ही सिक्के के दो पहलू हैं. एक के बिना दूसरा एग्जिस्ट नहीं कर सकता है. अक्सर जब हमें कॉलेज में या कहीं पर भी कॉन्स्टिट्यूशन के बारे में पढ़ाया जाता है, a lot of importance is given to 21 and 14. पर 14 बिना 15 के is meaningless. 14 gives you the right to be treated equally. But there have been so many judicial pronouncements जहाँ पे riders to that right have been attached. Those riders are if there is an intelligible differentia and if there is a reasonable nexus, the state can discriminate. तो वो तो 14 मान लो के गया क्योंकि स्टेट कैसे न कैसे किसी न किसी तरीके से ढूंढ ही लेता है वो इंटेलिजिबल डिफरेंशिया भी और रीजनेबल नेक्सस भी. तो 14 in itself has no value. That is why from 14 we move to 15. 15 clause 1 क्या बोलता है? The state will not discriminate on these grounds. So it will not discriminate on the ground of sex, creed, race, religion, etc. 2 और 3 बात करते हैं कि वो कहाँ अप्लाई नहीं होगा. So in while you are accessing public places, while you are accessing employment, etc. वो सारा है. 15 clause 4 उसका टोन ही अलग है 15 clause 1, 2 और 3 से. It starts first of all with the word notwithstanding. Notwithstanding is called any clause that begins with the word notwithstanding is called as a non-obstante clause. अब वो क्या बोलता है? Notwithstanding anything stated in clause 1, the state is free. The state can make laws favoring or empowering women, children, and members of the socially and economically backward classes. Yes, Rupali, exactly. तो अगर नॉट विथ स्टैंडिंग में हटा दूं 15 क्लॉज 4 में से, या फिर अगर कॉन्स्टिट्यूएंट असेंबली ने वो 15 क्लॉज 4 में नॉट विथ स्टैंडिंग नहीं डाला होता, what would have been the consequence? What would have been the logical consequence? Come on, somebody.
It's a special provision for the advancement and social and educational backward classes, ma'am, and citizen scheduled castes and scheduled tribes, especially.
Yes, Shivanand. But my question is slightly different. 15 clause 1 बोलता है state can not discriminate on the basis of gender, मान लो. 15 clause 4 बोलता है नहीं, state women के लिए special laws बना सकता है.
Ma'am, that's an exception. Ma'am, because I remember the Yusuf Abdul Aziz versus State of Bombay case, right? There it was challenged that women were getting special treatment against men. So that was generally because of the way women are situated in the society in India specifically, as it's more patriarchal. So even if
you are going in the what do you say, the discussion based on merits, that why is it so? It's an exception, I agree. But if you look at these two provisions, in isolation, do they point, are they divergent or are they convergent? Yes, Loveleen.
They are convergent.
They are convergent. They are convergent only when you read notwithstanding in Article 15 Clause 4. क्योंकि अगर मैं 15 क्लॉज 4 हटा दूं, उसमें से नॉट विथ स्टैंडिंग हटा दूं, 15 क्लॉज 1 एक डायरेक्शन में जा रहा है कि स्टेट डिस्क्रिमिनेट नहीं कर सकता, 15 क्लॉज 4 दूसरी डायरेक्शन में जा रहा है, दे आर डाइवर्जिंग। 15 क्लॉज 4 बोल रहा है नहीं, स्टेट कर सकता है डिस्क्रिमिनेट, औरतों के लिए, बच्चों के लिए, ईसीडब्ल्यू के लिए वो अलग लॉज बना सकता है। तो इसका मतलब सेम ही आर्टिकल में, सेम ही स्टैट्यूट में आपके पास ऐसे दो लॉज हैं, दो प्रोविजंस हैं जो एक दूसरे के ऑपोजिट है। तो कोर्ट के पास बार बार ऐसे केसेस आने वाले हैं जहां पे कोई 15 क्लॉज 1 को अप्लाई करना चाहेगा और कोई 15 क्लॉज 4 के अंदर बने हुए लॉज को 15 क्लॉज 1 के बेसिस पे चैलेंज करेगा। तो अगर कल को कोर्ट नया लॉ, लेजिस्लेचर नया लॉ बनाता है, तो वो चैलेंज किस बेसिस पे होगा? 15 क्लॉज 1 पे। और ये चैलेंजेस होते रहेंगे। तो उसकी वजह से क्या होगा, ना कभी पॉक्सो एक्ट आएगी, ना कभी डोमेस्टिक वायलेंस एक्ट आएगी। जितने भी लॉज हैं जहाँ पे विमेन हैव द पावर टू सीक रिलीफ फॉर डोमेस्टिक वायलेंस और क्रूएल्टी, वो सब रिपील हो जाएंगे। ओनली इफ यू डू नॉट सी द वर्ड नॉट विथ स्टैंडिंग। हाँ वीर बोलो।
नथिंग मैम, लास्ट में आपने वो वर्ड बोल दिया जब, तब मैं समझा कि क्या कह रहे थे आप। मैं वही सोच रहा हूँ कि मतलब पर्पस तो सेम सिंपल है ना, कि उनको भी इक्वालिटी पे लाने के लिए।
हाँ, लेकिन पर्पस अलग है। हमें ये समझना जरूरी
हाँ।
है कि दोनों क्लॉजेस का पर्पस अलग है। एक क्लॉज बोलता है कि आप किसी को अलग भेदभाव से नहीं ट्रीट करेंगे, दूसरा क्लॉज बोलता है कि वो डायरेक्टली ये नहीं बोलता कि आप भेदभाव कर सकते हैं, पर वो ये जरूर बोलता है कि आप अलग लॉज बना सकते हैं, आप स्पेशल लॉज बना सकते हैं। तो कोई अगर देखेगा टेक्निकली तो वो भेदभाव ही हुआ। कोई भी बोलेगा आदमी उठ के कि भाई ये लॉ औरतों के लिए है, फॉर एग्जाम्पल मैं अभी की बात ना करूं, आज से 2 साल 3 साल पहले की बात करूं, तो वी यूज्ड टू हैव डिफरेंट टैक्स स्लैब्स फॉर मेल्स एंड फीमेल्स। तो कल को कोई मेल उठ के जाके गोइंग टू फाइल अ पिटिशन चैलेंजिंग दैट प्रोविजन इन द इनकम टैक्स एक्ट कि व्हाई आर वुमेन टैक्स्ड लेसर देन मेन। तो दैट इज पॉसिबल only because of the word notwithstanding that exists in Article 15 Clause 4.
Yes ma'am, I agree.
Yes, Chetan.
For the advancement of scheduled castes and scheduled tribes, men, children, women can, without the substantial reason for the advancement of these groups, can state make laws like EWS, economically weaker sections.
Yes.
The central government have no any kind of data that who shows that these sections are economically weaker.
अनफॉर्चुनेटली डेटा होता है, लेकिन कितना उस डेटा पे रिलाई किया जाता है और उस डेटा का क्वालिटी कैसा है, वेदर दैट डेटा इज प्राइमरी इन नेचर और सेकेंडरी इन नेचर, और इज दैट डेटा कोरॉबोरेटिव, दैट इज ऑलवेज गोइंग टू बी ओपन टू स्पेकुलेशन। तो डेटा है जरूर, लेकिन पहली बात तो हमें भी पता है वो डेटा उतनी जल्दी अपडेट होता नहीं है। अगर हम सेंसस की बात करें तो वो हर 10 साल में होता है, उसमें भी जब कैलकुलेशन होती है तो उसके पैरामीटर्स बहुत अलग है। इंडिया एज अ कंट्री इज वेरी इट्स वेरी डिफरेंट इन अ लॉट ऑफ वेज। आप उसे ना डेवलपिंग बोल सकते हो ना डेवलप्ड बोल सकते हो, इट्स समवेयर इन बिटवीन। उसकी जीडीपी कई बार डेवलप्ड नेशन से भी ऊपर जाती है, बट उसकी जो सोशल कंडीशंस है, लोगों की कॉस्ट ऑफ लिविंग है, स्टैंडर्ड ऑफ लिविंग है, वो अभी भी जो डेवलपिंग कंट्रीज है उनसे मैच करता है। तो इसलिए ये जो कंसिडरेशंस है व्हेन इट कम्स टू इकोनॉमिकली वीकर सेक्शंस ऑफ द सोसाइटी, दैट इज ऑलवेज अ वेरी ट्रिकी क्वेश्चन। इसीलिए भी शायद कोर्ट ने जब वो क्रीमी लेयर वाला कॉन्सेप्ट इंट्रोड्यूस किया, in terms of caste based discrimination or caste based reservation, they at least tried to reconcile it कि आप हो सकता है कि लोअर कास्ट से हो, established लोअर कास्ट से हो, लेकिन अगर आप इकोनॉमिकली उतने वीक नहीं हो, आपको इकोनॉमिकली सपोर्ट की जरूरत नहीं है, तो आप वो कास्ट बेस्ड रिजर्वेशन का इस्तेमाल नहीं कर सकते, आपको वो एडवांटेज नहीं मिलेगा।
And then why central government don't formulate rules?
Chetan, I can't hear you properly. Can you be a little louder?
Ma'am, why central government can't establish a rule for creamy layer for the scheduled caste and scheduled tribes?
बेचारे इलेक्शन हार जाएंगे ना अगर उन्होंने बना दिया ऐसा लॉ, तो दैट इज द प्रॉब्लम। उनकी वोट बैंक चली जाएगी. Yes, Loveleen.
Ma'am, I was about to talk about creamy layer concept and you covered it.
All right. So that's all from my side. I think we had a very fruitful and a very constructive discussion. Thank you so much for bearing with me and bearing with this how bad I'm sounding. But thank you so much. Thank you to the Lawyers Junction, to the organizing committee, and to such great participants who were not only present, but they were also contributing to the discussion that we have. I hope that today we not only because it's, and I'm not saying this because it's Republic Day, but I want us to understand. I remember reading somewhere that Dr. B.R. Ambedkar once said that when you look at democracy, there are two ways, there are two kinds of democracy. We have social democracy and we have political democracy. Without social democracy, political democracy cannot sustain. So what we follow as a principle enshrined in our preamble is it is aiming towards political democracy. But without social democracy, taking its place and holding on to the Indian society, political democracy will be meaningless. So I hope that we are able to imbibe that in ourselves, and at our own level, in our own small ways, we are able to uphold the principles that are enshrined in our constitution, the preamble of our constitution. Thank you so much. I see a couple of raised hands. If you have any questions, feel free.
Ma'am?
Yes, Niyati.
Just as our preamble very much states about justice and equality as such, and after the decriminalization of Section 377, this question has been forever and still lingers about transgender community, as they have suffered since eternity, to say, and still is. But do you think it's making any difference at, like, we're in 2022 now? Do you think it makes any difference right now also? Because there's a lot of struggles for them even now.
It is, and see, I also believe that the Navteej Singh Johar judgment, unfortunately, doesn't do anything for the transgender community. I mean, it is good for the LGBTQI community in general, but when it comes to transgenders, whether the ones who do it, to earn money, or the ones who, transform into the gender that they align themselves with and they're more comfortable with, unless and until that gap is going to be filled, where, see, we do talk about freedom of expression, but it's an empty freedom. If you do not allow, if even if till today, if you do come across people who've chosen to transition to another gender, to another sexual orientation, even now the society is not still very forthcoming. तो वो गे और लेस्बियन तक तो फिर भी चलो थोड़ा बहुत मैं मानती हूँ कि नवतेज सिंह जौहर की वजह से थोड़ा सा there is a slight mind shift. At least they can rely upon that judgment to fight for their rights. But unfortunately, it doesn't really do anything for transgender community. The only law that they can rely upon is the bill that is still pending. That bill is also very weird and not drafted properly, not having a lot of humane considerations that it should be keeping in mind. पता है क्या, मुझे ऐसा लगता है कि I feel there's a lot of similarity between the transgenders bill, and if you look at the anti-conversion laws that were started in states like UP, they passed a anti-conversion law. वहां पर भी क्या है, there was a provision that said that if you decide to convert for the purpose of marriage, you will have to, the person who's converting you, they will have to go and prove that this is not conversion only for marriage. The onus will lie on them. If you think of it logically, it doesn't really make sense. मैं शादी के लिए कन्वर्ट करूं या मैं शादी करने के बाद कन्वर्ट करूं should not really make much of a difference, at least when it comes to punishing anti-conversion or punishing criminalizing conversion. The same way when you look at the transgenders bill, where they have to undergo extensive administrative and executive scrutiny, that they have to provide papers that when they go for sex reassignment surgery, they have to notify to the government, and so many other things. Those, unless and until you harmonize those things, this is always going to be a sore issue. I have a sore throat, so
I don't recall exactly, but it does state that the ones who decide to change their gender by surgeries, they shouldn't be considered into that criteria.
hmm.
As like even one of my friends who is at the moment transitioning, it's my childhood friend, so
Hmm.
from a woman to being a man, like she's a privileged, I'd say he's a very privileged person at
Yes.
the moment because of a very supportive family and
Hmm.
everything. But when it comes to job opportunities, though he did get an opportunity in Chandigarh also, but there's if they have places reserved for them to have that job opportunity, but the discrimination that they do suffer and the way he said that he was treated and looked upon made him leave that job. And
Yes.
even not having gender neutral washrooms for them too, it's a very big issue
Yes.
even in universities.
Absolutely, absolutely. I remember because I love watching movies and I love, incorporating references from movies in my classes. I remember hearing this dialogue in Jolly LLB, the first one, where, there's a monologue by the judge who's played by Saurabh Shukla. And he says that, even till today, when two people fight, they always caution each other, they always give a warning that I shall see you in court. So it does mean that people still, if they ever have a choice, they still rely on courts. They still rely on the idea of justice that prevails, in the corridors of our courts. And they still believe that somewhere or the other, when there's going to be a tussle or a fight between the legislature or the executive and the judiciary in terms of entitlement of rights, fundamental or otherwise, the judiciary definitely will weigh in their favor. So let's hope that someday we do have another landmark judgment, which is going to be revolutionary for transgenders' rights. So looking forward to that.
Yes, ma'am, we do consider them, take their blessings and everything, invite them for functions and all, but then we fail. That saddens me that we fail to protect them as human beings.
Yes, absolutely. Yes, Sumitra.
Yes, ma'am. Thank you, ma'am. Thank you for the opportunity. Ma'am, could you please detail the concept of judicial activism when compared with the judicial adventurism?
I actually sit on the fence on this one. I don't believe that it's either of the case. It's actually a balanced approach. Judicial adventurism goes against the principle of separation of powers, because when the judiciary becomes too proactive and it starts meddling into affairs of any other entity which is not its place and not its job to do, that is what we call as judicial adventurism. Whereas judicial activism is a necessity in a progressive democratic society like India, where the concept of justice is so dynamic and it is so volatile that it changes from person to person. You cannot expect the law making process or the law amendment process to match the society. So when we say the law influences the society and the society influences the law, it is supposed to be that the law and society match each other, they match each other's space. But we all understand that in India specifically we follow bicameral legislature. So wahan bringing changes in law, bringing new law is a very tedious and a very cumbersome process, and hence judicial activism becomes extremely important. But I believe that if you look at the Indian scenario in today's time in 2022, going from 2021 to 22, I believe that we are rightfully still largely rooted in judicial activism. We do have here and there slight cases of judicial adventurism where judiciary tried to get into something that was not their place, or at least not at the right time. But I believe that they're largely focusing on judicial activism, and all for a good cause. I like to, as I said in the beginning, I'm an optimist and I like to look at, I want to be grounded in reality, but I like to look at the good things as well. So, what all the judiciary, the Delhi High Court and the Supreme Court, the Bombay High Court, whatever they have done during the pandemic for migrant laborers and for other sections who were affected, I believe that is commendable, and we should give some credit wherever it is due.
Yes, ma'am. Got it, ma'am. Thank you so much, ma'am.
Yes. Chetan, I still see your raised hand. You have another question?
Yes, ma'am. Ma'am, as you told that India is a sovereign country from the starting of establishing constitution in our country, then
Yes.
why the Kashmir issue is in United Nations? Does India have power to retake back from the Pakistan without intervening United Nations?
Chetan, I lost you towards the end. What did you say about after Pakistan?
Ma'am, can we retake Jammu and POK, Pak occupied Kashmir from the Pakistan without intervening from the United Nations?
If
Because
we are
we have a sovereign power.
we have sovereign power only over India. And as you rightfully say, if it is Pak occupied Kashmir, which means that India does not have control or any access to to that part of Kashmir, then automatically it goes beyond our sovereignty. So it has to be it has to be referred to a supranationalist organization, and that's what it is.
But ma'am, actually, Raja Hari Singh of Jammu and Kashmir has acceded Jammu and Kashmir wholly to the part of India.
Hmm.
But why we have don't sovereign power to over Pak occupied Kashmir now?
Because there have been a lot of changes, including the wars that we have fought with Pakistan, and as a result of which progressively Pakistan was able to capture certain parts of Kashmir. So ऐसा नहीं है ना कि उस समय राजा हरि सिंह ने जितना दिया था आज भी हमारे पास उतना ही है. अगर उसमें चेंजेस आए हैं पॉलिटिकल रीजंस की वजह से, डिप्लोमेटिक रीजंस की वजह से, सो यू विल हैव टू लुक एट दैट फ्रॉम द प्रेजेंट पॉइंट ऑफ व्यू एंड देन टेक अ कॉल. हैड इट स्टिल बीन ये वही बात हो गई चेतन, जैसे मान लो कि देयर इज अ पीस ऑफ लैंड, उस पर दो भाइयों को लेके झगड़ा हो रहा है. एक भाई बोलता है कि देयर फादर, दे आर बोथ what you say real brothers, so one of them is claiming that the father made a will and betrothed all that property to the first son. The second son is claiming that no, he made another will and in that will he's given the other son the right. उस केस में ये डिस्प्यूट नहीं हो रहा है कि वो उस डिसीज्ड की प्रॉपर्टी है या नहीं है. दैट्स नॉट द पॉइंट. पॉइंट ये है कि आउट ऑफ दीज टू विल्स, इफ दीज बोथ किड्स आर एबल टू प्रोड्यूस देयर रिस्पेक्टिव कॉपीज ऑफ विल, द क्वेश्चन इज कौन सी विल वैलिड है. कौन सी विल के समय विल बनाने वाला जो टेस्टेटर था, ही वाज इन द राइट फ्रेम ऑफ माइंड एंड ऑल अदर थिंग्स, व्हिच इज द लेटेस्ट आउट ऑफ द टू एंड ऑल दोस थिंग्स. सिमिलरली जब यहाँ पर अगर कश्मीर इंडिया के पास ही होता वो हिस्सा भी, तो जाहिर सी बात है इट वुड हैव बीन अ क्वेश्चन अवेलेबल दैट वुड हैव गॉन बिफोर द सुप्रीम कोर्ट ऑफ इंडिया. But now that it's not in India's control anymore, obviously it can't be something that the Pakistan government gets to decide, or the Pakistan judiciary or the Indian judiciary. It has to go to a third entity which is supranationalist in its nature. And supranationalist का मतलब है कि हम थोड़ी थोड़ी अपनी sovereignty जब किसी international organization को देते हैं, when we become members of that organization, that is how supranationalism originates. तो अभी जो issue ऐसा है, because it is outside the political boundary of India, it is pertaining to the Pak occupied Kashmir, it is inevitable that it can only be approached before a supranationalist organization. It can't be managed at the Indian level.
But ma'am, ma'am, many kinds of functions of a central government shows that POK is also a part of Kashmir, like a member of parliament that are given in our constitution also contains the member from the Pak occupied Kashmir, and the weather showing a performance of a central government also contains that Pak occupied Kashmir is a part of India. Then how we can say that the Pak occupied Kashmir is out of control from the India?
I'm sorry, Chetan, I am not aware of
Oh,
all
okay,
those
ma'am.
things. Thank you.
Okay,
Thank
ma'am.
you,
Got
Chetan.
it. Thank you so much.
Yeah. All right. Over to you, Bhaswat. Yeah. Okay. Veer, you have a question?
नो मैम, मतलब यही पूछना था मैम कि जैसे प्लेबिसाइड्स का भी डिसीजन तो हुआ था, बाद में सीज फायर भी तो हुआ था, नेहरू जी गए थे उनके पास, तो वो वैसे ही अपनी सोवेनिटी उन्हें ले जाके सौंप आए कि मतलब आप डिसाइड करो कि क्या होना चाहिए कश्मीर में. तो वहाँ पे जब ये सारी चीज़ें हो गई, तो वो जो ट्रीटी हुई थी राजा हरि सिंह और पटेल मतलब इंडिया के बीच में, तो उसकी वैल्यू उतनी मतलब रह नहीं गई ना, क्योंकि बाद में हमने प्लेबिसाइड्स भी तो नहीं कराए ऐसे अगर देखें तो. तो जब तक वो प्लेबिसाइड्स नहीं हुआ तब तक ये, इसीलिए रणबीर पेनल कोड वाला सीन चल रहा था. तो वो सारे इश्यूज भी हो सकते हैं ना पीओके ना लेने का, या वहाँ अपनी सोवर्निटी ना दिखा पाने का इंडिया को, क्योंकि यूएन में हम गए थे, हमारी साइड से हम पहले गए थे.
हाँ, और मुझे तो ऐसा लगता है कि यूएन तक जाने वाली बात भी तभी होती है ना जब ऐसा नहीं है कि अपने लेवल पे हम वो चीजें सॉल्व कोशिश नहीं करते. वो कोशिश होती है, लेकिन जब हमें ऐसा लगता है कि हमारी बात नहीं सुनी जा रही है, एंड पाकिस्तान एज अ कंट्री इज नोटोरियस फॉर दैट, सो समटाइम्स यू विल वांट टू एक्सरसाइज सम एक्सटर्नल इंटरनेशनल प्रेशर.
यस मैम, मतलब हाँ ये भी रीज़न है, और वो मतलब गए वो जो भी रीज़न हो, क्योंकि वो डिस्कशन का पार्ट फिर बन जाएगा कि जाना, पर हाँ ये भी.
All right. Over to you, Bhaswat.
Yes, ma'am. So now I would like to call Yash for question now.
Yeah, so let's dive into the questions. So if anyone has more questions, like they can type it in the chat box, or like they can simply raise their hand and ask more questions. Ma'am, I believe there are questions in the chat box that may or may not be answered. Ma'am, you're on mute.
I think Rupali has asked some question. Why not? There are some prominent law that allows such people, giving them proper space to live their life. Rupali, I believe you're talking about the transgender community. Okay. Rupali, that's what I was, saying in response to what Niyati was asking, that we do have a transgenders bill which seems to recognize. Now we do have the Nalsa judgment. Anupama has rightly pointed out where the law has accepted and acknowledged the transgender community as a third gender. Thankfully, that is the reason why in a lot of forms that we go fill in government offices and otherwise also, you are now able to see the third column for other gender or other. So it's male, female, and other. पहले वो नहीं होता था option. It was either male or female. So that is the contribution of that NALSA judgment, that the recognition for the transgender community is there. But unfortunately, so far as they're laying down their rights substantively, their recognition and their incorporation, in various forms of society, that is dependent upon the transgender bill that originated in 2018 and has not been passed yet. So unless and until, और वो भी इसलिए passed हुए because उस bill में भी बहुत सारे problems है, जैसे कि we were talking about. तो जब तक वो that is the only law that they can cater to, and that bill is yet to become a law. So until that happens, unfortunately, they cannot seek any legal protection per se. But हाँ, Article 21 के अंदर person word use होता है. तो आप चाहे मेल हो, फीमेल हो, ट्रांसजेंडर हो, all of you are entitled to equal protection of law, equal treatment before the law, and if any legal procedure or law will deprive you with your life and personal liberty, it can only be done in a just, fair and reasonable manner. So it's not that just because you do not fit into the gender stereotypes of the society, the law does seem to accommodate the transgenders so far for Article 21, so far as Article 21 is concerned. I hope that answers your question, Rupali.
Yes, ma'am. Thank you.
Yeah, so I believe like everybody have asked their questions. If not, then you can raise your hands and ask your questions now, or else we can go for the vote of thanks. Yeah, someone
Yes,
else raised
Chetna.
them.
Good evening, ma'am. I want to ask for how to well prepare for judiciary exams.
Judiciary exams. Now, see, you will have to first, Chetna, look at which states are you targeting, because different states have different. First of all, their syllabus is slightly different. Like, for example, there would be states like Rajasthan, Maharashtra, where they do focus on local laws as well. So whatever local laws pertaining to property, rent, stamp act are there, focus on that. So find out the syllabus first based on the preferences for your state. And then so far as the basic preparation is concerned, I believe the focus should always be on procedural law, CPC, CRPC, and constitution. If you focus on these three, all other laws, unless and until there's any additional local law that you may have to read as a part of the syllabus, it will take care of most of your subjects. Because when we study constitutional law, we also attach with it administrative law. और अगर आपका CPC, CRPC, admin और consti हो गया है, more than half your battle is won. Any other question, Cheta?
No, ma'am. Thank you.
All right. I think that's about it. I don't see any more raised hands.
Yes,
Sure,
ma'am.
ma'am.
Sure. Thank you, ma'am, for such a valuable interactions and your points. Now, I would like to call Ganga to conclude the webinar and give vote of thanks.
Good evening, all. This has been a very special day for Team Lawyers Junction as we successfully organized our first webinar in our journey. We hope you all benefited from this discussion and would be able to use it in your future. Firstly, I would like to thank Anu ma'am for sparing some time from her busy schedule to preside over this webinar. Thank you for making this session lively and interactive. It was a pleasure to have you with us. Secondly, I would like to thank each of you who attended and interacted this event and helped us make it a success by being patient listeners. Lastly, I would like to thank the whole team of Lawyers Junction for their efforts, which made this event possible on such a short notice. Thank you all for your patience and cooperation. And before concluding, I would like to inform you all that you will receive your e-certificates soon via your registered mail. Good day to all.
Thank you so much.
Thank you, ma'am.
Thank you, ma'am. Thank you.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank
All
you.
the links have been posted.